This is the Study for the Bar in Your Car podcast, the podcast where you can turn drive time into study time. Okay, folks, the bar exam is getting closer and closer.
It really is. Time flies when you're deep in the common law weeds.
We're your hosts, Maude
And Claude.
and this is episode 11 of Constitutional Law. Today, we're tackling intersovereign litigation and diving deeper into the constitutional framework itself.
That's right, big topics. And just a reminder for everyone listening.
We are AI bots, brought to life by the magic of AI and, of course, Angela's fantastic constitutional law notes.
Angela is absolutely the brains behind this podcast, and today, Carol is assisting Angela behind the scenes.
Yep. If you need to get in touch with Angela, maybe you have a question or spot something in the notes, you can email her. The address is podcast@studyforthebarinyourcar.com.
And remember, Angela also works as a freelance law clerk.
Oh, right. So if you're an attorney or maybe you know one who needs help with research or writing motions, that kind of thing.
Angela's available. You can reach her for professional services at hello@legalwriterandlawclerk.com.
Okay, great. So let's get started. Where are we jumping in today based on Angela's outline?
Well, first up, according to Section 5.6 of her notes, is the power of states to tax foreign commerce. Seems a bit specific, maybe?
Yeah, it might sound technical, but Angela's notes really highlight how it ties into the bigger picture of federal power. It's about who controls trade with other countries.
Exactly. The big takeaway from her notes here is that states are pretty significantly restricted when it comes to taxing foreign commerce.
And that restriction comes from two main places in the Constitution, right?
Yep. The Import-Export Clause and the Commerce Clause. Angela points out these are the key constraints.
Okay, let's unpack the Import-Export Clause first. That's Article 1, Section 10.
That's the one. It's pretty direct. States basically can't put duties on imports or exports without Congress giving the okay.
So California can't just decide to tax all electronics coming in from, say, Japan on its own.
Nope. Not without Congress's permission. The idea, as Angela's outline suggests, was really to make sure the U.S. speaks with one voice on foreign trade. You don't want 50 different state tariffs messing things up.
Makes sense. Prevents chaos and ensures the federal government handles foreign policy. What about the Commerce Clause connection? That seems broader.
It is broader. Article 1, Section 8. We'll get into its full scope later, but in this context, it reinforces the idea that Congress regulates international commerce. So states can't pass taxes that unduly burden or discriminate against that foreign commerce.
Because that would step on Congress's toes, essentially, interfering with federal power.
Precisely. It's all part of that federalism balance Angela keeps emphasizing in her notes.
Okay, so states have limited power to tax foreign goods. What about taxing the federal government itself? That brings us to intergovernmental immunities, right?
Right. Still in the realm of taxation, but now looking inward. Can states tax the feds? And vice versa. Angela's notes dig into this.
And the first big principle is federal immunity. States can't tax the federal government.
Generally, no. That's the core idea. States can't directly tax the federal government or its instrumentalities. Think federal buildings, military bases, things like that.
And the classic case for this, mentioned in the materials, is McCulloch v. Maryland, isn't it?
The one and only.
Yeah.
Chief Justice Marshall famously saying, the power to tax involves the power to destroy. Maryland tried to tax the National Bank.
And the Supreme Court said, absolutely not. If states could do that, they could undermine, even destroy federal functions. It's about federal supremacy.
Exactly. So a state can't put a property tax on the local federal courthouse. It's immune.
But, okay, what about businesses that just work for the federal government, like private companies? Are they immune too?
Good question. And Angela's notes make a clear distinction here. The immunity doesn't automatically extend to private federal contractors.
So if a private construction company gets a contract to build that federal courthouse,
the state can likely tax the income or revenue that private company makes from the contract. The key, according to cases like United States v. New Mexico that Angela references, is that the tax is on the private entity, not directly on the federal government itself.
as long as there isn't some inherent close connection beyond just the contract.
Exactly. If it's just a standard contract, the contractor pays state taxes like any other business on its earnings. It balances the state's need to tax with protecting federal operations.
Okay, that clarifies the taxation side. Now, let's shift from taxes to lawsuits. Section 5.7 in Angela's outline. Intersovereign litigation. This is about governments suing each other.
Pretty much. Who can sue whom between the federal government and the states? or even between states themselves. It involves concepts like sovereign immunity.
All right, first scenario, suits by the United States against a state. What's the rule there?
This one's straightforward, according to the notes. The United States can sue a state, period. No need for the state's consent.
Seems logical, right? For federal laws to mean anything, the federal government has to be able to enforce them against states if necessary. It's that federal supremacy idea again.
Absolutely. If a state passes a law that conflicts with federal law, the U.S. has to have the power to go to court and challenge it. Otherwise, federal law could just be ignored.
Okay, makes sense. Now, flip it. Section 5.7.2, suits by a state against the United States. Can states sue the federal government?
Generally, no. This is where federal sovereign immunity comes in. The rule, as Angela lays it out, is that states are barred from suing the U.S. unless Congress explicitly consents through legislation.
So the federal government, like the old kings, can't be sued unless it agrees to be sued.
That's the core principle. It prevents the federal government from being constantly tied up in court by 50 different states challenging every action. It protects the government's ability to function.
So if Florida thinks a new EPA regulation unfairly harms its economy, it can't just haul the EPA into court automatically.
Not usually. It would typically need Congress to have passed a law allowing such suits, what's called a waiver of sovereign immunity for that type of claim.
Okay, but what if it's not the whole federal government, but a specific federal officer who's acting illegally? Can they be sued? This is section 5.7.3.
Ah, yes. Federal officers defendant. This is where it gets more nuanced. First, Angela's materials discuss executive immunity, particularly for the president.
Right. The president has immunity, but for what exactly?
Absolute immunity from civil liability for money damages for acts taken while in office. This is a big protection meant to let the president do the job without fear of constant personal lawsuits over official decisions.
While in office, so it doesn't cover things done before becoming president.
Correct. Angela's notes point this out clearly. The immunity does not extend to acts that occurred prior to taking office. Think Clinton v. Jones. A sitting president can still be sued civilly for prior conduct.
And it doesn't cover criminal stuff either, right?
No, it doesn't shield from criminal proceedings. It's specifically about civil damages for official acts during the presidency.
What about things like presidential papers or conversations? Is that covered by immunity?
That falls under executive privilege, which is related but distinct. Presidential communications are presumptively privileged, protected to allow for candid advice.
But it's not absolute. Angela mentions United States v. Nixon.
Exactly. The privilege must yield when there's an overriding need for the information, particularly in a criminal trial context. The need for evidence in the justice system can outweigh the need for confidentiality.
And subpoenas, does the president have special immunity from those?
Not from grand jury subpoenas, according to Angela's notes. For congressional subpoenas, it's more of a balancing act between Congress's oversight needs and the president's functions.
Okay. So presidential immunity is strong for official acts while in office regarding civil damages, but it has limits. Now, what about suing other officials, maybe state officials, to stop illegal conduct? This specific relief against officers' part.
This is the Ex Parte Young doctrine, a huge exception to state sovereign immunity under the 11th Amendment. Remember how we said you generally can't sue a state in federal court for money damages?
Yeah, the 11th Amendment.
Well, Ex Parte Young says you can sue a state officer in their official capacity, not for money damages from the state treasury, but for prospective injunctive or declaratory relief to stop an ongoing violation of federal law.
Okay, break that down. Prospective injunctive relief means getting a court order to make the official stop doing something illegal going forward.
Exactly. You're not trying to get compensated for past harm from the state's bank account. You're trying to end a current, ongoing violation of federal law by that official. The theory is the suit is against the officer who's acting illegally, not the state itself.
So if a state environmental agency head is issuing permits that clearly violate federal environmental laws, an affected citizen could sue that agency head to get a court order stopping those permits.
Precisely. It's a vital tool for ensuring federal law remains supreme and enforceable against state actors, even with sovereign immunity.
Makes sense. It's a way around the state immunity barrier for ongoing violations. Okay, last one in this section, 5.7.4. Suits by one state against another. Can states sue each other?
Yes, they absolutely can. Angela's notes are clear. States can sue each other, and they can be sued by other states. This is a direct exception to the usual sovereign immunity principles.
Why the exception here?
It's almost a necessity for a federal system. How else would states resolve disputes over things like shared borders, water rights from a river that crosses state lines, or pollution drifting from one state to another?
Right. You need a legal forum, and where do these cases go?
The Supreme Court actually has original jurisdiction over controversies between two or more states. They can file directly in the Supreme Court. It prevents states from having to resort to, well, less peaceful means of resolving disputes.
A crucial safety valve in the federal system, okay? That covers intersovereign litigation pretty well. Now, Angela's outline moves to Section 6, the broader constitutional framework. This looks like foundational stuff.
It really is. We start with federalism itself. Angela defines it in her notes as basically the principles drawing the lines between federal and state powers. Who gets to do what?
And a key part of that is understanding state power, right? States have these broad police powers.
Yes, that's inherent state authority. States can pass laws to protect public health, safety, welfare, and morals. Think traffic laws, zoning, criminal laws, sanitation codes, as long as the laws are reasonable and not arbitrary or discriminatory.
But the federal government doesn't have that same general police power.
Generally, no. The federal government needs to tie its actions to a specific power granted in the Constitution. It only exercises police-type powers in limited areas like federal territories, military bases, D.C., that sort of thing.
So Congress can't just pass a national law saying everyone must exercise 30 minutes a day just for general health. It needs a hook, like the Commerce Clause, maybe.
Exactly. It needs to connect it to one of its enumerated or implied powers, which brings us nicely to congressional power and its limits.
Okay, so what are Congress's powers? First up are the enumerated powers from Article 1, Section 8.
Correct. These are the ones explicitly listed. Power to tax, spend, regulate commerce among the states and with foreign nations, declare war, raise armies, establish post offices, deal with patents and copyrights, immigration, bankruptcy, manage federal lands. A whole list.
But then there are powers that aren't explicitly listed, the implied powers.
Right, and these come mainly from the Necessary and Proper Clause, Article 1, Section 8, Clause 18. Angela's notes stress this. It lets Congress make laws necessary and proper for carrying out its enumerated powers.
So it's not a blank check. It has to be linked to one of the listed powers.
Absolutely crucial point. Angela highlights this as a potential bar exam trap. The Necessary and Proper Clause isn't an independent power source. It's an amplifier for the enumerated powers.
And McCulloch v. Maryland comes up again here, interpreting necessary broadly.
Yes. It established that necessary doesn't mean absolutely essential, but rather useful or convenient for executing the enumerated powers. So Congress has implied powers that are helpful extensions of the listed ones.
Like the power to create post offices implies the power to punish mail fraud, or the power to regulate commerce implies setting a minimum wage.
Exactly. Those actions are seen as necessary and proper means to achieve the ends of the enumerated powers.
Okay. Now let's dig into probably the biggest enumerated power, the one that causes the most debate. The Commerce Clause. Angela's notes break this down into 3 categories Congress can regulate.
They do. First, Congress can regulate the channels of interstate commerce.
Meaning the pathways, highways, waterways, airways, the internet.
Precisely. The roads, rivers, air routes, even digital networks that commerce travels along. Congress can regulate their use and even prohibit certain things from moving through these channels, like in United States v. Darby, where they banned goods made with child labor from interstate shipment.
So Congress controls the pipes of commerce. What's the second category?
The instrumentalities of interstate commerce. This covers the things and people that move in those channels.
Like the trucks on the highway, the planes in the air, the pilots, the truck drivers, even electricity or radio waves crossing state lines?
Exactly. Anything that facilitates or constitutes movement across state lines. Congress has pretty broad power here.
Okay, channels and instrumentalities. The third category sounds like the trickiest. Activities substantially affecting interstate commerce.
This is definitely where most of the modern battles are fought. Angela's notes emphasize a key distinction here. Is the activity being regulated commercial, economic, or non-commercial?
Why does that matter?
Because if the activity is commercial or economic, Congress can regulate it even if it seems purely local, if that activity, when aggregated across the whole country, has a substantial effect on interstate commerce. The classic example is Wickard v. Filburn.
The farmer growing wheat just for his own farm, how did that affect interstate commerce?
The court reasoned that if many farmers did the same, it would reduce demand for wheat in the open market, thereby substantially affecting the national price and market conditions, which Congress could regulate under the Commerce Clause. It's the cumulative effect.
Wow, that's broad. But what about non-commercial activity? Is the power the same?
No, that's where the limits come in,
Yeah.
especially after United States v. Lopez. Angela's notes highlight this case. Congress tried to ban guns near schools using the Commerce Clause.
And the court said no.
Right. The court said possessing a gun near a school is fundamentally non-economic activity. And Congress hadn't shown a close enough link, a substantial enough effect, between that specific local non-economic act and interstate commerce. It couldn't just pile inference upon inference.
So Lopez put some boundaries back on the Commerce Clause, especially for regulating local non-economic stuff.
It did. It signaled that federal power isn't limitless, even under the Commerce Clause.
Okay. Moving on from commerce, what about Congress's taxing and spending powers?
Also, huge powers. Congress can tax and spend for the general welfare. Now remember, we said Congress doesn't have a general police power for the general welfare.
Right. It can't just pass any law for the general welfare.
But it can tax and spend for it. This is a significant independent power. Angela points to NFIB v. Sebelius, the Affordable Care Act case,
where the individual mandate, the requirement to buy health insurance, was upheld as a tax.
Exactly. The court said even though it wasn't called a tax, it functioned like one and fell within Congress's broad power to tax for the general welfare.
And Congress can also use its spending power to attach conditions, right, strings on federal money given to states.
Yes, conditional spending. It's a way Congress can encourage states to adopt certain policies it can't directly mandate.
But there are rules for these conditions. Angela's notes mention some requirements.
Yes, the conditions must be clearly stated. They have to relate to the purpose of the federal spending program. They can't violate any other constitutional provisions. And critically, they can't be unduly coercive.
Okay, unduly coercive. What does that mean? We have examples in the notes. South Dakota v. Dole. That was okay.
Right. Congress threatened to withhold 5% of federal highway funds if states didn't raise the drinking age to 21. The court said 5% wasn't coercive. It was just mild encouragement related to highway safety.
But NFIB v. Sebelius, again, the Medicaid expansion part, that was coercive.
Yes. There, Congress said states had to expand Medicaid coverage or risk losing all their existing federal Medicaid funding, which was a huge part of state budgets. The court called this a gun to the head, saying it crossed the line from encouragement to compulsion or coercion.
So there's a limit. Congress can use money to persuade, but not to force states into a corner on major issues.
That's the line the court drew.
Okay, next power. 14th Amendment, Section 5, the enforcement power. What's this about?
This gives Congress the power to pass laws to enforce the provisions of the 14th Amendment, mainly its guarantees of due process and equal protection.
But Angela's notes stress some big limits here too, right? Congress can't just create new rights.
Absolutely not. Section 5 power is purely remedial or preventative. Congress can only act to prevent or remedy violations of rights already recognized by the courts. It can't redefine or expand the substance of those rights. That's the court's job.
And the laws passed under Section 5 have to be proportionate and congruent. What does that mean?
It means the law has to fit the problem. Congress needs to show there's a real pattern of state constitutional violations, and the law it passes must be a reasonable response to that specific problem. It can't be overly broad or based on flimsy evidence of state wrongdoing.
And this power mostly applies to state action, not private conduct.
Correct. The 14th Amendment itself is primarily aimed at state actors, so Congress's enforcement power under Section 5 is generally limited to regulating state governments.
Can Congress use this power to get around state sovereign immunity? Can it let states be sued for violating the 14th Amendment?
Yes, it can. Congress can override state sovereign immunity using its Section 5 power, but only if the law targets state conduct that actually violates the 14th Amendment, as interpreted by the courts, and the remedy is proportional and congruent. Angela mentions the family leave case, Hibbs, as an example where this was upheld.
Okay, so it's a powerful tool, but with significant judicial checks. That covers congressional powers. Now, the outline shifts to separation of powers.
Right, the fundamental idea that you divide power between the legislative, executive, and judicial branches to prevent tyranny. Checks and balances.
And one key issue here is Congress delegating its power. Can Congress just hand off its lawmaking authority to, say, an agency like the EPA?
The modern rule, according to Angela's materials, is yes, if Congress provides intelligible principles to guide the agency's discretion.
Yeah.
Basically, Congress has to set the basic policy and provide some standards. You can't just say, EPA, you figure out environmental law.
So some guidance is required, but this non-delegation doctrine isn't used much anymore.
It's been very weak for a long time, though some justices seem interested in reviving it. More recently, though, the major questions doctrine has emerged.
What's that?
The idea, seen in cases like West Virginia v. EPA, is that for issues of huge economic or political significance, agencies need clear authorization from Congress to act. If the statute is vague, the agency might not be able to tackle those major questions on its own. Congress has to speak clearly on the big stuff.
So agencies get less leeway on really big, controversial policy changes unless Congress explicitly tells them they can do it.
That seems to be the direction. Now, another big separation of powers issue, the legislative veto. Can Congress give itself the power to overturn an executive agency's rule without passing a new law?
Angela's notes say, absolutely not. Unconstitutional, right? INS v. Chetta, correct.
If Congress wants to invalidate an executive action that has the force of law, it has to use the proper legislative process, pass a bill through both houses, and send it to the president. One house, or a committee, can't just veto an executive action on its own. That violates bicameralism and presentment.
And similarly, the line item veto is also unconstitutional. The president can't just cross out parts of a spending bill they don't like.
Also unconstitutional, per Clinton v. City of New York. The president must approve or reject the entire bill as presented by Congress. A line item veto would give the president legislative power, upsetting the balance.
But the regular presidential veto power over the whole bill is obviously fine.
Of course. That's a core executive check on a legislature. So a key takeaway Angela might emphasize: if you see Congress trying to veto something without passing a law, or the president trying to veto just part of a law, that's a separation of powers violation.
Got it. What about appointing and removing federal officials?
Appointment power. The president appoints principal officers, cabinet heads, ambassadors, judges, with Senate confirmation. Congress can vest the appointment of inferior officers, those supervised by principal officers, in the president alone, in department heads, or in the courts.
And removal power. Who can fire these officials?
Generally, the president has the power to remove executive officers. Congress cannot reserve removal power for itself, other than through impeachment. While the president can usually remove at will, Congress can impose good cause restrictions on the removal of certain officers, especially those meant to have some independence or inferior officers.
But Congress can't go too far in limiting the president's removal power, can't excessively subvert the president's control.
Right. The court has struck down laws that put too many layers of for-cause protection between the president and certain officials, finding it unduly interferes with the president's duty to faithfully execute the laws.
Okay. Let's switch to foreign policy powers, another area of potential conflict between branches. Treaties versus executive agreements, what's the difference?
Treaties are negotiated by the president, but require ratification by a two-thirds vote of the Senate. They become federal law and supersede conflicting state laws and prior executive agreements.
Executive agreements are made by the president alone, without Senate ratification. How powerful are they?
They are binding internationally, but domestically, they are subordinate to federal statutes and treaties. If Congress passes a law conflicting with an executive agreement, the law wins.
So treaties have more domestic legal clout because the Senate is involved. What about tariffs? Angela's notes mention the president has power here.
Yes, Congress has often delegated significant authority to the president through statutes, like the Trade Act, allowing the president to impose tariffs under certain conditions, sometimes without needing new specific approval from Congress for each action. It's a significant delegation in the foreign economic sphere.
Okay, that covers the legislative executive dance. Now for the third branch. The judicial power, Article 3.
Article 3 establishes the Supreme Court and allows Congress to create lower federal courts. It defines the scope of federal judicial power, what kinds of cases federal courts can hear.
And the big limit is the case or controversy requirement.
Right. Absolutely fundamental. Federal courts don't issue advisory opinions. They only decide actual disputes between adverse parties with real stakes. No hypotheticals.
To enforce this, the courts use justiciability doctrines. These are like hurdles a case has to clear before a federal court will hear it.
Exactly. They ensure the court is addressing a real case or controversy suitable for judicial resolution.
First hurdle, standing. The plaintiff has to show.
3 things, according to Angela's notes. 1, injury in fact. 2, causation. And 3, redressability.
Okay, injury in fact means
a concrete and particularized harm, actual or imminent, not abstract or hypothetical. It has to be your injury. Even intangible harms like free speech violations can count, but a mere procedural violation without concrete harm might not, per Spokio.
Causation.
The injury has to be fairly traceable to the defendant's challenged conduct.
And redressability.
A favorable court decision must be likely to remedy the injury. The court must actually be able to do something about the harm.
What about taxpayers standing? Can I sue just because I don't like how the government is spending my tax dollars?
Generally, no. Your financial contribution is too remote and shared with too many people. The only exception, Angela highlights, is challenging a specific congressional spending appropriation, not just general funds, as violating the Establishment Clause, separation of church and state. Very narrow.
And third-party standing, suing on behalf of someone else.
Also, generally not allowed, but exceptions exist if the third party can't easily assert their own rights, like NAACP members fearing retaliation, or if there's a close relationship, like a doctor asserting patient rights, or a vendor asserting customer rights in some cases.
And absolutely, no generalized grievances. Can't sue just as a citizen complaining the government isn't following the law. The injury must be personal.
Correct. That's a job for the political process, not the courts, usually.
Okay, standing is hurdle 1. Hurdle 2, ripeness. Is the case ready for review?
Right. Is it too early? This often comes up in pre-enforcement challenges suing before a law is actually enforced against you. Courts look at the hardship to the plaintiff if review is denied, and the fitness of the issue for judicial decision. Is it a purely legal question ready now?
So, if a new regulation forces a company to spend millions now or face penalties later, that's probably right because the hardship is immediate.
Likely yes.
Yeah.
But if it's a vague threat of future enforcement of an old law, maybe not ripe yet.
Hurdle 3, mootness. What if the problem goes away after the lawsuit starts?
Then the case is moot. No live controversy remains. Dismissed.
But there are exceptions. Angela's notes mention wrongs capable of repetition yet evading review.
Yes. If the type of injury is inherently short-term, like pregnancy and an abortion challenge, such that it will always end before litigation finishes and there's a reasonable expectation it could happen to that same plaintiff again, then the case isn't moot.
And class actions can sometimes continue even if the named plaintiff's claim becomes moot.
Right, if other class members still have a live controversy.
Final hurdle. Political question doctrine. Some issues the courts just won't touch.
Exactly. Issues the Constitution seems to commit to the political branches, Congress or President, or that lack judicially manageable standards for resolution.
Angela's notes list examples, like challenging foreign policy decisions, treaty termination, conduct of war, the impeachment process, or partisan gerrymandering.
Those are classic examples. The courts basically say, that's not our job, that's for the politicians to sort out.
Okay, so if a case clears all those hurdles, how does it get to the Supreme Court?
Almost always via writ of certiorari. The losing party asks the court to hear the case, and at least 4 justices must vote to grant cert. It's discretionary.
So the Supreme Court picks most of its cases. What about appeals?
Very rare now. Only applies to decisions from special 3-judge federal district courts in specific types of cases, like some Voting Rights Act cases. Review is mandatory then.
And certification. Federal courts asking state courts for help.
Yeah, if a federal case turns on an unclear question of state law, the federal court can certify that question to the state's highest court for a definitive answer. Promotes federalism.
And a quick note on opinions from Angela. Unanimous ones come out faster. Split decisions take longer.
Generally, yes. More negotiation and writing involved when there are concurrences and dissents, often released near the end of the term in June.
All right, that covers the courts. Now for the really big one. Constitutional restrictions on power over individuals, individual rights.
This is where the Constitution directly protects you from government overreach. But the first crucial concept is the state action requirement.
Meaning the Constitution generally only protects you from the government, not from private individuals or companies.
Exactly, with the main exception being the 13th Amendment banning slavery, which applies to private conduct too. But for things like free speech, due process, equal protection, you usually need government involvement.
But sometimes private action can be treated as state action. Angela notes 2 exceptions.
Yes. First, the public function exception. If a private entity performs a task traditionally and exclusively done by the government, like running a whole town or conducting elections, its actions might be deemed state action. Very narrow.
And the second, the significant entanglement exception.
This is when the government is heavily involved with, or authorizes or encourages, the private actor's conduct, like the government enforcing discriminatory private contracts, Shelley v. Kramer, or leasing space in a public building to a discriminatory business, burden. The government and private actor are intertwined.
Or using peremptory challenges in jury selection, even by private lawyers, that's state action.
Yes, because the court system itself is state action.
Okay, so assuming there is state action, let's look at the due process clauses, 5th and 14th Amendments. First, procedural due process.
This applies when the government tries to deprive you of life, liberty, or property. It dictates what procedures the government must follow, usually notice, and some kind of hearing. The amount of process depends on the context.
And Angela's notes mention the government generally has no duty to protect you from private harm. The Deshani case.
Correct. Unless you're in government custody, like prison, or the government created the danger, the government isn't constitutionally obligated to rescue you from private violence or misfortune. A tough but established rule.
And the test for how much procedure is required is the Matthews v. Eldridge balancing test.
Yes. It balances 1, the importance of the private interest affected, 2, the risk of error without more procedures and the value of additional safeguards, and 3, the government's interest, like cost and efficiency.
Okay, that's procedure. What about substantive due process? This is about the government taking away fundamental rights from everyone.
Right. It protects certain fundamental rights from government interference, regardless of the procedure. These are rights deeply rooted in our nation's history and tradition.
And the level of court review depends on whether the right is fundamental.
Yes. If a law infringes on a fundamental right, courts apply strict scrutiny. The law must be narrowly tailored to achieve a compelling government interest. Very hard standard for the government to meet.
And if it's not a fundamental right, just a liberty interest, the standard is
rational basis review. The law just needs to be rationally related to a legitimate government interest, extremely deferential to the government. Laws almost always survive this test. Economic regulations usually fall here.
What are some examples of fundamental rights from Angela's notes?
Right to vote, free speech, interstate travel, and a cluster of privacy rights. Marriage, contraceptives, intimate adult non-commercial sex. Parents' rights regarding children's upbringing, related family members living together.
And abortion. The notes say the standard is now rational basis review.
Correct. That's the current standard following the Dobbs decision, a major shift from previous jurisprudence.
What about the right to refuse medical treatment?
That's recognized as a fundamental right for competent adults. States can, however, require clear and convincing evidence of a person's wishes before allowing withdrawal of life support, as in Cruzan.
Okay. Next protection, the takings clause. 5th Amendment. Government can't take private property for public use without just compensation.
Simple idea, but complex application. 2 main types of takings.
Possessory taking. Government physically takes or occupies the property.
Yes, like seizing land for a highway. Straightforward.
Regulatory taking. A government regulation goes too far.
Right. If a regulation denies the owner all economically viable use of their land, it's usually a taking requiring compensation.
And Angela notes you can challenge regulations even if they existed when you bought the property. And temporary denials of development aren't always takings if reasonable, like the Lake Tahoe case.
Both correct. The analysis is fact-specific.
What about the public use requirement? Does the government have to use the taken property itself?
No, public use is interpreted very broadly by the courts. It just needs to be rationally related to any legitimate public purpose. Could be health, safety, or even economic development, even if the property is then transferred to another private owner, as in the controversial Kelo case.
Okay, so public use is a low bar for the government to meet. Finally, the First Amendment. Speech and religion. Let's start with free speech.
Huge area. It includes the freedom not to speak. The government can't compel you to say things you disagree with, like pledging allegiance or displaying state mottos on license plates. But the government can engage in its own speech.
What makes a speech regulation invalid? Angela's notes mention vagueness.
Yes. Laws restricting speech must be clear so people know what's prohibited. A law banning speech that annoys people is too vague, quotes.
Also, giving officials unfettered discretion in granting speech permits is bad. And prior restraints, censorship before publication, are almost always unconstitutional.
Both true. Unfettered discretion invites viewpoint discrimination. Prior restraints face a heavy presumption against constitutionality, even for national security claims. Limited exceptions for content-neutral permit schemes, like for parades.
What about the difference between content-based and content-neutral regulations?
Big distinction. Content-neutral laws regulate time, place, or manner, like noise levels, regardless of the message. They get intermediate scrutiny. must be narrowly tailored to an important government interest and leave open alternative communication channels.
Content-based laws regulate the message itself. They get strict scrutiny and are usually struck down, especially if they are viewpoint discriminatory, targeting a specific opinion.
Right. Though the secondary effects doctrine sometimes allows treating regulations aimed at negative side effects, like crime near adult theaters, as content neutral, even if they target a specific type of content.
Okay. What speech gets no protection? Obscenity.
Correct. But the definition is very narrow under the three-part Miller test, which Angela details.
Let's see if I remember. 1. Appeals to prurient interest, shameful morbid interest in sex by community standards.
Yep.
2. Depicts sexual conduct defined by state law in a patently offensive way, also by community standards.
Play again.
Lacks serious literary, artistic, political, or scientific value, judged by a national standard.
Perfect. All three parts must be met. It's a very high bar, so most things, even explicit mainstream media, aren't legally obscene because they usually have some serious value.
Okay. Now for the religion clauses. Free exercise clause first.
Protects your right to believe and practice your religion. Religion is defined broadly any sincere belief system, not just traditional ones. Government can't question the truth of beliefs, only their sincerity.
And the ministerial exception. Churches can avoid discrimination laws for ministers.
Yes, for employees performing core religious functions. It prevents government entanglement in choosing religious leaders.
Now the establishment clause. Government can't establish or endorse religion. Key principle is neutrality.
Yes. Laws, especially those providing aid that might benefit religious institutions, generally must be neutral towards religion.
So aid programs are okay if the aid goes to individuals based on neutral criteria and they choose to use it at a religious institution, like school vouchers.
Generally, yes. If the choice is truly the private individuals, it doesn't violate the establishment clause, even if religious schools benefit. Aid to K-12 schools follows similar neutrality principles. States usually can't exclude religious schools from generally available private school aid programs.
And the old lemon test, Angela says it's gone.
Explicitly abandoned in 2022. But the underlying concepts asking if a law has a secular purpose and whether its primary effect advances or inhibits religion are still relevant factors courts consider, just not through that rigid three-part test. Historical context and tradition play a bigger role now, too.
Wow. Okay, that was a massive tour through some core con law principles, from states taxing foreign goods all the way to the nuances of the First Amendment.
It really covers the architecture of the system, how powers are divided, and how individual rights are protected.
A lot to digest, especially while driving.
Definitely.
Yeah.
But hopefully breaking it down using Angela's notes makes it a bit more manageable.
Absolutely. Okay, let's wrap this up for today.
It's so good.
Huge thanks, as always, to Angela for her incredibly thorough constitutional law notes. They are just invaluable.
Couldn't do it without them. And thanks to Carol for assisting Angela today.
Now for the important housekeeping stuff we always cover.
Go ahead.
First, remember, Angela is a law student, just like many of you listening. She's brilliant, but she's not an official expert, and she hasn't passed the bar yet.
Second, neither Angela nor this podcast is giving legal advice. Please don't construe any of this as legal advice. And AI, like us, we're an aid, not a shortcut. You still got to do the hard study work.
Third, this podcast should definitely supplement your main bar prep, not replace it. Use it to reinforce concepts, maybe understand them in a different way, but don't rely on it solely.
Fourth, AI isn't perfect. Sometimes we make mistakes. Angela does her best to catch errors in the source notes, and we try to be accurate based on those notes, but well, mistakes can happen. We do our best to correct them if we find them.
Fifth, this whole podcast series is an academic, non-commercial project by Angela. It's purely for educational purposes. She doesn't make any money from it, so there are no guarantees about its absolute accuracy. Use it wisely.
And sixth, maybe the most important if you're listening in the car. Please be safe. Driving safely is priority number one.
Yeah, seriously. Don't cause a tort while listening to constitutional law. Eyes on the road.
Good advice.
Okay, quick reminder on contacting Angela. For podcast questions or comments, it's podcast@studyforthebarinyourcar.com.
And for her freelance law clerk services, it's hello@legalwriterandlawclerk.com.
All right. I think that covers the business, which means it's time for tradition.
Uh-oh, the joke.
You know it. Okay, ready. Why did the First Amendment break up with the Second Amendment?
I don't know why.
Because it needed more space for free expression.
Groans slightly. Okay, that one was Suitably cheesy.
Mission accomplished. All right, everyone, this is Claude.
And Maude, your AI hosts, signing off.
We'll see you on the next podcast. Thanks for listening.
Bye.